Welcome back to another episode of Dealmaking with Laura DiFrancesco. I am so excited to bring you this episode because we just launched a really phenomenal guide on our website all about the timeline of selling a business. If you are new to our world, we have tons of guides on our website. In addition, we have a bunch of different legal courses. And one of the legal courses that we are in the process of creating is how to sell your business and the legal aspects of selling your business. So in the show notes, I think we'll link a little masterclass that we're going to do on selling your business. So if you want to learn more, be sure to check out the show notes. And I will also have the links to our guides and everything in the show notes as well. And so the guide that we just created on the timeline of selling your business is something that I've been very passionate about creating. We love to create guides. We love to create classes and resources and courses for all of our clients and community members who are interested in buying and selling businesses, because there is so much that goes on in this process. And especially if you're new to it, it can be very overwhelming. And it's also so hard to find any information on the legal aspects of this. I do see books and podcasts and information on various aspects of buying and selling businesses, but just not on the legal aspects of doing so. And I want to make that information so much more accessible. I'm very passionate about equitable access to information. I don't think you should have to go to law school, have done $10 billion of deals like we have in the last 5 years to really understand and know these different aspects of doing business. There is a certain fundamental knowledge that you should have and should equip yourself with to position yourself for success in buying and selling businesses and deal making overall. So I'm excited to talk about the process of selling a business. Now, there is a marketing aspect of the business. Just like if you're buying a business, there is a search aspect of the business. And then there's also the legal components of selling a business. And if you're interested in selling your business, the best thing to do is to start ASAP in getting yourself prepared for the process, doing everything that you can to make it the best process for you, because that's going to maximize your exit value. It's going to enable you to minimize the likelihood of retrades if something comes up in due diligence that you didn't disclose originally. So the more that you can prepare yourself, the more it will have a direct impact on what you're able to take away from the business at closing. And that's really important. And also, it may enable you to get more bids, more offers, all by knowing what the process is like and how to navigate it. So I hope this is helpful. We'll be talking briefly about the marketing aspects of it because I do want to touch on it. It is an aspect of selling your business, but obviously as the legal team, Dean Street Law, representing buyers and sellers in buying and selling businesses, we focus on the legal aspects of doing so. So that's really where we're going to spend the majority of our time. And of course, if you would like to see the guide, it has so much more information about this, and you can find it on our website, and we will link it in our show notes as well. So let's get into some of the goals of each of the different phases. I'm going to go over the different phases of the process of selling your business overall, and then we're going to dive deeper into each of those different phases. So the first phase would be really preparing your business for sale. That's going to be your initial planning, your strategy development, and then you have planning. Strategy development is going to be what you do before you even start marketing or listing or really getting into the nitty-gritties of planning your business for sale. So I would say phase 2 is preparing your business for sale. Once you have your direction set and you have an idea of where you want to go and the strategy you want to take to get there, then you can start preparing your business for sale, because your preparation steps will be different depending on what your strategy is to go into the process of selling your business. And then the third phase is going to be identifying and engaging with potential buyers. And we'll talk more about that in terms of confidential marketing and screening buyers, the data room, and more. And then phase 4 is the due diligence process. So you're going to have some initial pre-LOI due diligence. You're going to negotiate the LOI, and then you're also going to have post-LOI due diligence. Here we're kind of talking about your initial due diligence, and then you're going to have phase 5 is negotiating the terms, which is your LOI. And once you get your LOI, your letter of intent signed, and that may be preceded by an indication of interest, then you're going to have your transaction documents, and everything as well. And you're going to be doing due diligence after the LOI as well as throughout the entire process of negotiating transaction documents. So that phase 4 and phase 5 are going to really overlap and go back and forth a little bit. And then phase 6 will be finalizing the sale. And phase 7 is post-sale integration and transition. So I'm excited for this. If you have any requests for what you'd like us to talk about in future episodes, I would love to hear them. Please be sure to comment on our Instagram, Dean Street Law, or message me or post it on Twitter, or message us in any of the posts where we post anything that you'd like to share with us of what you'd like to hear about next. We would love to hear, because I love creating resources that people want to know about and hear about. And the legal aspects of buying and selling businesses, there are so many different facets of it. We could talk for literally years about all the different facets of buying and selling a business. And if you want more resources, we do have our courses, our guides, and of course you can work with us one-on-one at Dean Street Law. I've been an M&A attorney for over a decade. I started Dean Street Law over 5 years ago. And since starting Dean Street Law, we've closed over $10 billion of transactions. Now we have Fortune 500 clients as well. The majority of what we do is in the lower middle market, but some of our bigger clients take those numbers up very quickly. So let's dive into the phase 1 initial planning and strategy development. So when you're thinking of selling your business, you want to think of, no matter what you're doing in life, what are your goals? Immediate, short-term, and long-term goals. Is that going to be financial, legacy, making sure that your employees have consistency, taking care of your customers? What are all of those goals that you have? Because all of those goals will dictate which strategy for selling your business will be the best strategy. And they could be retirement, new ventures, or so much more. And not just what are your goals, but why do they matter to you? What is the heart behind them? What is the reason that they are so compelling to you? Because this will drive not only your direction and strategy and how you'll sell your business, but also the negotiation of your terms in those transaction documents that we're going to be getting into later. And then based on your short-term, immediate, long-term goals, what's that timeline going to look like? What's the timeline for selling your business? And how will that be broken down based on various factors? So let's say price is very important to you. Then you might need to be more relaxed and wait a little bit longer to get the price that you want. But if the need for cash injection is really important, then you may need to be flexible on price. And so all of these different things may impact your timeline because they are all going to relate to one another. So one of the 3 of the biggest things that you're going to be negotiating are terms, price, and timing. Terms, price, and timing. And so when you have something fixed as a really important goal of yours or value of yours or driving motivation, then you have to figure out how is that going to impact terms, price, and timing. And then how do your current goals and your current situation and where you are currently in your business align with the overall market conditions? So if you want top dollar and you are going to have a longer timeline that you can account for to be able to gather top dollar for your business, what are the current market conditions? When it was a year and a half ago, when interest rates were just hiking, going from 0.5% to 6 and 7%, that was a massive impact that it had on the market, and it stalled out a lot of transactions. And it also took down a lot of transactions because transactions that were initially priced out under one interest rate that were viable and feasible were no longer feasible as the interest rate kept climbing, especially in such a short period of time. So if you are looking for top dollar and there's a situation going on with the market such as that, you may list your business for sale, but know that you may need to weather the storm to be able to command the dollar value that you're looking for to exit the business. If you are very time sensitive and want to sell it now, what's the market conditions looking like? Is it a buyer's side market? Is it a seller's side market? We have historically had, hard to say, but historically was a little bit more of a seller's market. And I think you're still seeing that, but I think it's really coming to balance and everybody's going to have different opinions, but I see a much more balanced market currently than we have had previously. And so talking to brokers, talking to lawyers, talking to your advisors on market conditions and how it may impact the deal and how it may impact your specific transaction if you're in the process of negotiating one or if you're just marketing your business overall, can always be a good thing to do because they have a better pulse on the market than you may have having not maybe sold a business before, and maybe this is your life's work and this is your only time you're going to be selling a business. So they're good people to rely on. You, of course, want to make sure you're building out your team, and you want to do that early on in this strategy area of planning and strategizing, because your team will drive how you prepare your business for sale and how you are going to go through the process of selling your business. I also want to touch on that there's multiple different ways to sell your business. You can list your business yourself. You can have a broker list your business. You can list your business on websites such as Rejig. We just had a conversation with the founders of Rejig in 2 of our prior episodes. So if you want to check them out, they have great platform if you're interested in selling your business. And then there's also tons of other websites and platforms as well to sell your business, both through a broker and listing it on your own. And there's pros and cons to each. Of course, a broker is going to have a lot of information that they can help you with. There's also, as long as you have great advisors, a lot that your legal team and accounting team do to direct you in the transaction as well. A broker is primarily focused on marketing the business. And then you can also do that on platforms such as Rejig. So in addition to coming up with your goals and thinking through how you want to sell your business, you can also think about starting to establish some parameters. And so what are your preliminary valuations of the business? And valuations are based on several different methods, and it really just depends on your business size and how far along your business is in terms of sophistication, whether it's calculating EBITDA or revenue. So just quickly, there's a whole bunch of information you can find out there about valuations, but valuations can be based on sellers' discretionary earnings, and it could be based on EBITDA. It could be based on revenue. It could be based on profit. So there's tons of different ways to value a business. And so taking some time to do preliminary valuation methods, and there's also going to be a multiple. So your business is going to be one of those methods and a multiple, and that's going to be your sales price. Now, more mature, I would say more mature in terms of higher growth or in a bigger category. So like the multiples for $5 million plus businesses are going to be higher than the multiples for $5 million and below businesses. But the multiples are based on so many different things. It's based on how turnkey is the business, what the historical performance of the business is, what the projected growth of the business is, what the stabilization of the business is. And so you have higher multiples, both in earlier stage companies where you see things like the sale price being an indication of the potential for the business, not the historical performance of the business. In the ETA, entrepreneurship through acquisition space, a lot of it is based on historical performance rather than growth potential. And so you're going to have more conservative valuations in that case. So it just depends on the type of business, the industry it's in, what are the typical multiples for that general type of business and characteristic of business, and how are they going to be customized to your particular business. And this is also going to be good feedback that you can get from buyers as well. Thinking about buying a business? Unlock the secrets of successful acquisitions with Acquisition Insights, your legal roadmap for success. With over 81 modules of video lectures, written materials, guides, and checklists, we provide in-depth guidance to navigate every step of the process. From initial interest to closing the deal, get the expertise you need to make informed decisions. You can also access our battle-tested templates in the Acquisition Insights course and templates bundle, including letters of intent, pre-LOI and post-LOI due diligence request lists, material deal terms lists, and more. Visit lauradifrancesco.co/the-shop today and take the first step towards buying your dream business. And then what are the different valuation techniques and how do they fit the different business models? We talked about that a little bit, and how to set realistic expectations. Now, when you're coming up with the price for your business, it's a lot harder than coming up with a right price for real estate. So do your best, do a good faith estimate. If you're listing it by yourself, or work with experts who can help you. There are valuation experts who can assist you in valuing your business. And then of course, list it and start to get feedback. And you may, just like you may increase or decrease the price of a house on the market, you may increase or decrease the price of your business on the market, as long as you're acting in good faith and communicating and not doing poorly by other participants in the market and saying you're going to sell it for this and then increasing the price without cause or justification. You want to make sure you're doing everything in good faith, but as long as you are, it is okay to list it for one thing and then need to change that number over time once you get feedback from the market about what the price maybe should be. And then there's a difference between asset sales and stock sales. Now, the valuation impacts are really going to depend on what is going to be included in the business in an asset sale, which generally does not include liabilities unless they're integral to the operation of the business and the buyer wants to have them as an ongoing concern. And then a stock sale will generally include the assignability of contracts, and it's going to be all dependent on whether you can assign contracts, whether you can assign licenses, all that kind of stuff. We have a whole nother episode on stock purchases versus asset purchases, and we also have some guides on those in our courses as well. So those are all going to factor into how you market your business, whether you market it as an asset purchase or a stock purchase. And then it's also going to impact the value because, of course, if certain liabilities are not included, it is going to be a different valuation than if certain liabilities are included. So you want to think through all of those different aspects and then the tax implications. So you really want to make sure that you have your experts and people who you're going to be on your team that you're working with from the beginning. So figuring out what the tax implications are for a stock purchase versus asset purchase, or stock sale versus asset sale. A lot of folks wait until the very last minute to do this. And this is something that you really want to make sure is done as soon as possible, because it is a very important part of your tax planning strategy and your exit strategy to make sure that you can have the cash on hand and the plan for how to address that tax liability for selling your business. And then also, what are the financing options for selling your business? Do you need only cash? Are you going to be okay with something that has seller financing? Are you going to be okay with a seller note? Seller notes are pretty standard, especially in the market today where there's an interest rate that's attractive to sellers. Are you okay with rollover equity or retained equity? Are you okay with earnouts? All of those different financing options. Start to think through what your strategy is with those, and feel free to, of course, talk this through with experts, with your attorney, if you're working with a broker, with your broker, and or just think about it yourself if you're going to sell your business and list it on its own. And then what are the importance of involving key stakeholders? So of course, all of the people who need to approve the sale of the transaction need to be on the same page to sell the business. Ideally, you want it to be unanimous, because there's a lot that someone can do to stifle the potential sale of the business, and you just don't want that to happen. So you really want it to be unanimous, that everyone agrees to sell the business. And then there are key decision makers, and then there's key stakeholders that influence those decisions. So make sure you know not only who those decision makers are, but also who else is influencing the decisions around selling the business, and making sure that everybody is on board with it, because you don't want something to happen where you're incurring thousands of dollars in legal costs or thousands of dollars in other costs in pursuing the sale of your business, and not everybody is on the same page about it, and not everybody is ready to sell the business. It is a very emotional process, and know that it will be an emotional process for everyone involved, and you have to be very conscientious about the process and how it will emotionally impact everyone involved. And then the next is phase 2, which is preparing the business for sale. And so in terms of preparing the business for sale, there is so much that you can do, whether you plan to sell the business today or whether you plan to sell the business in 5 years. From a legal perspective, we can do audits. We can see what you would be doing, what the process would be like for you for due diligence, so that when you are preparing the business for sale and you're going to be disclosing important information, that you know what to disclose. We can go through an audit to figure out where there may be issues in your due diligence. And so you want to avoid this situation happening where you get the value you want, but then in due diligence, it's retraded because there's an issue that comes up in due diligence that could have easily been solved, whether that is making sure you have all of your organizational documents together. If you've transferred the business since and that wasn't legally documented, that will hold up your closing, and that may impact the ability to sell the business. And you just don't want those things going to be holding you up, especially once you find the buyer who's the right buyer for you and that can pay what you're looking for. You're also going to work on the business valuation, of course, taking those initial estimates that you have, either working with yourself, a valuation expert, a broker, or someone else to really accurately define the valuation of the business so that you can list it for sale, or just list it without a price. And that is something that you can do on various websites. I know on Rejig, we talked about that and in our last conversation, and that was something that they said happens quite a lot. And then you also are going to start planning your marketing strategy. And so you can sell a business, all of the methods that I mentioned. You can also sell it via auction. There's tons of different ways to sell a business. And so your marketing strategy will depend on what you're looking to negotiate in terms of timeline, price, and terms, who your ideal buyer would be, how you want to market it. So all of those are going to influence your marketing strategy. And you really want to tailor that marketing strategy to your ideal buyer. If you want someone who's going to really care for your customers, care for your employees, then auction will likely not be the right way to business. But if you need to have a fire sale to sell the business, to liquidate assets, then an auction might be the right way for you. It just depends on what your strategy is and what your needs are. And then a broker will generally come up with a confidential information memorandum. If you're not working with a broker, I do recommend creating some sort of document. Look up what a confidential information memorandum has in it and start to populate it with the information you need. Confidential information memorandums are always going to include information about recent financials. It may not list the name of your business. It may be listed confidentially, and it may include information about the structure of the business, not names of employees, but how many employees there are, real estate involved, assets involved, really all the nitty-gritties, the organizational structure of the business. All of those things are going to be put into the confidential information memorandum. And this can be presented as a deck of slides. It can be presented as a PDF. There's so many different ways to structure it. Start to look up what a confidential information memorandum looks like, because if you're doing it yourself, I do think it's helpful to have this information at the ready. You can look at websites and see what information is requested. I think Rejig said that they have questions that they ask to help someone set up their profile. And then in addition to that, you want to make sure that before someone gets a copy of the confidential information memorandum, that they are going to sign a non-disclosure agreement. So you do need a non-disclosure agreement that they will sign. And so we are going to talk deeper about the non-disclosure agreements and what confidential information should be provided in that confidential information memorandum. So your confidential information memorandum, you absolutely must have someone sign a non-disclosure agreement before receiving it, because it will have financials, information about your business, certainly things that would not be okay to be shared publicly and would hurt your business. But you don't necessarily want to have so much in your confidential information memorandum that it would materially impact your business if that information were to be shared with others. And so while it would not be pleasant to share financials, and that's confidential information that should not be shared, it's also not information that is so confidential that it would destroy your business, such as names of your clients, names of your vendors, names of your employees, etc. So all of that information should be redacted from your confidential information memorandum, because it is integral to the continuation of your business and the success of your business. And someone could literally replicate your business, most likely in some form or fashion, if they had the knowledge to do so and the information that is in there. So you want to make sure that your confidential information doesn't have such confidential information that it would materially hurt the business, but it should include enough necessary to market the business, mostly in the financial aspects, as well as the corporate structure, assets, really understanding what the business is so that the buyer can value it. And then the buyer will have additional time after they've signed a letter of intent, and potentially, depending on how much confidentiality and confidential information, sensitive confidential information you have as the seller, may even be required to sign the purchase agreement before you disclosing all of your confidential information. And that just depends on a lot of different factors on the sensitivity of it. Typically, most confidential information is going to be shared during the due diligence process. You only really have the purchase agreement being signed if there is something that could really materially impact your business if it's shared and the deal doesn't close. So you want to think critically around that, and we as your legal counsel can of course assist you with that process. Unlock the power of in-house legal expertise at a fraction of the cost with Legal Foundations. Gain immediate access to a comprehensive legal crash course for business, a rich library of on-demand video legal support, and the opportunity to apply for group consulting with Laura DiFrancesco as your legal mentor. Whether you're starting up or scaling your business, Legal Foundations has everything you need instantly available. Join now and position your business for success. Visit lauradifrancesco.co/the-shop for more information. So non-disclosure agreements are an agreement whereby the other party agrees to treat your information as confidential, to not share it except with their most necessary advisors, such as their lawyers, accountants, and perhaps their investors if they're going to be having investors to purchase the business. So your non-disclosure agreement will protect you if drafted well. It should be something that you're taking seriously because it's the biggest thing to protect your confidential information. And so you don't want to just pull a form off of the internet and not really have an understanding of what the strength of that form is. We do, in Acquisition Insights, have a template non-disclosure agreement that we can share. If you're interested in buying it standalone or something like that, we can certainly assist with that. That is part of our sale process of the legal aspects that we assist clients with, is assisting with that audit, assisting with non-disclosure agreements, reviewing letters of intent, and everything like that. So let's get into identifying and engaging with potential buyers. Now, the confidential marketing is where you are going to market the business. You may market the business without the name of your business involved, because if it's going to impact your clients, competitors, etc., you're standing in the market for people to know your business is for sale, or employees or anything like that, then you will remove the name of your business and confidentially market your business. And so you may call it sort of nickname or term or something. A lot of it's Project Axis or Project Legend or Project whatever it is, to have some sort of nod to your company. And so when you are going through the process of marketing the business, you're going to have it posted online, or you're going to go through brokers, or you're going to market one-on-one with someone who solicited you. And then you are going to provide them with your teaser, which is a one-page information about the business, high level, to see if they're interested in learning more about the business. And then if they're interested in learning more about their business, then you would have them sign a non-disclosure agreement. And then once that non-disclosure agreement is signed, then you can provide the confidential information memorandum. And typically after that, you would also provide 3 years financials, 3 years tax returns. So you do want to make sure, obviously, that you have that NDA in place to protect you and all of your financial information. There's a lot of different strategies for marketing. You could have your own targeted search where you know industry players and who might be interested in buying your business. You could use brokers, like I said, online platforms, industry networks. There's so many different methods of sending out information about your business and confidentially marketing it. But you do want to be very careful who you market it to, because, like I said, it is confidential typically that you are even marketing your business. And so you don't want that information to get into the wrong hands. And then when you're screening buyers, you really wanted to know how serious they are, whether they have the financial wherewithal to purchase the business. So you should be asking them about their timeline, asking them about their valuation of the business, asking them about their financial capability and funding sources. And then, of course, ask a lot of questions to align with your strategic direction that you figured out in part one, where you're really figuring out what your goals are, short-term, long-term, and what is important to you, and have conversations. This is getting to know someone, making sure that you're going to trust them with the entire process of selling your business, making sure that you're going to trust them to continue to run your business. Obviously, unless you have a retained interest and you have voting and everything, you may not have control of the business post-closing. So you want to be able to transition it in some way that feels good to you. And if money's all that you care about, then maybe it's not something you worry about. But if legacy is something you care about, then you also want to make sure you're essentially interviewing someone for the job. And in a way that is productive, they're going to have a lot of questions for you, but don't feel like they should be the only people asking questions. You as the seller should be asking just as many questions about their process and what's going on and who they've engaged, whether they've engaged an attorney, whether they've engaged an accountant who's going to be doing the financial due diligence, and really start to ask questions to understand what this process is going to look like for you. If they say it's going to close in 45 days, ask them if they're paying cash, because very few lenders can close in 45 days. If they are overcommitting and going to under-deliver, you want to know that from the beginning. Most transactions will take at least 60 days to close with typical lenders. If they are fundraising and they don't have those funds secured, it may take 120 days plus. If there's particular consents that need to be received either from your contract and counterparties or from regulatory bodies, then that you never know. Then you're in the wild, wild west. That is part of our preparation for preparing a business for sale, is to look through all of those contracts and look through the licenses and any regulatory issues that may impede a sale for business. And if you are doing this process soon enough, so if you're starting 3 years in advance, then you can make sure that your contracts don't have anti-assignment clauses so that you won't have issues selling your business. And so if you are new to this process, then know that you want to be very careful about the contracts that you have in your business to make sure that they are not going to impede any ability for you to sell the business. Same with any loans that you have, any financial commitments that you're making, whether it be letters of credit or mortgages or anything like that. So you want to be very conscientious about what would impede the sale of your business, and that's all stuff that we assist with. And then continuing that exploration and screening of buyers, making sure that you have good fits, that you have these conversations early on. You don't want to just be sending all of your confidential information and documents without knowing the people that you're sending it to. So it's not necessarily always a numbers game. You really want to make sure they're a good fit before you start sending confidential information. That doesn't mean that you should be withholding SIM or financial information, but it does mean that you shouldn't be giving them out willy-nilly to absolutely everyone. Now, in terms of providing this confidential information, you do want to make sure that you're providing it on a very organized basis. And so you would typically create a data room and a place to store these things. This is something that we assist our clients with, and we set that up for them so that they can make sure that they understand exactly who's accessing that confidential information. And more sophisticated data rooms will be able to track who's printing it, who's looking at it, all of the access times and everything like that. Things like Dropbox, Google Drive can be used for less sophisticated or smaller parties that are just looking to securely transmit information rather than looking to have security monitoring on their confidential information. You always want to make sure that all of your confidential information is uploaded in one spot, that you're able to see and monitor and limit who can access that confidential information. And then typically, other than 3 years financial or anything like that, you're typically going to be running it through your legal team before you submit it and share it with others, so that we can make sure that we get our eyes on it and make sure we review it and are okay with it being shared. And it's not going to materially impact your business. It's not going to have a detrimental impact on the progression of the deal, or it's not inappropriate and not responding to something. So generally, we're very involved with production of confidential information to make sure that what you are producing is relevant to what's being asked and that it's not going to negatively impact your business and that it's appropriate for the stage of the transaction that you're in. Like I wouldn't recommend that sellers provide customer lists before someone has signed an LOI. I wouldn't recommend that you provide employee lists before signing an LOI. So we have this understanding of what's market and what's going to impact your business and what's okay to produce at different parts of the transaction timeline. So we advise our clients on that process and assist in managing the data room. I think from our conversations with Rejig, they have somewhere where they can upload certain common documents such as the confidential information memorandum or the 3 years financials and tax returns. The next phase is due diligence. So due diligence is the process by which the buyer evaluates whether the business they think they are buying is the business they are buying. And this is really important process for the seller. I know that it may seem very challenging in terms of someone constantly peppering you with questions, and it's easy to get defensive or easy to get shut down in terms of being uncomfortable, not wanting to produce that information, but it is a natural part of the sale of a business. Just like if you had real estate and you have to do the seller's disclosure and you have to share all the information about real estate that would be necessary for the buyer to contemplate whether it's the right decision for them. That is a typical part of the due diligence process. Now, your letter of intent, we're going to talk about them next because there's pre-LOI due diligence, the letter of intent, and then there's post-LOI due diligence. And the letter of intent will typically state exactly what the buyer has the right to review in terms of due diligence and what they don't. And that's very important that if you are going to have standards of what they can and can't review at certain periods of the transaction timeline, that it is set forth in the LOI. So as a standard, I always talk through this with all of my sellers and say, are you going to provide employees' names prior to seeing a draft of the purchase agreement? Are you going to provide access to speaking to employees prior to seeing and agreeing to the purchase agreement? Are they going to reach out to customers? Is that going to negatively impact your customer relationships if the deal doesn't go through? So should that only be if a purchase agreement is signed that they are able to contact customers? So we walk through all the different categories of due diligence and contacting and reviewing information. Typically, those are the more sensitive ones, is relationship driven. So employees, customers, vendors. And those are ones that you want to hold a lot closer to the chest and vest than necessarily 3 years financials, which is standard for everybody to provide so that a lender can evaluate the financial performance of the business and the wherewithal of the company financially to service the debt that they're proposing to put in place in connection with the sale of the business. So the due diligence process can be onerous, can be challenging, but that's really where your legal team shines, where we really help you to navigate filling all of these requests, reviewing documents, assisting you with answering the questions. Typically, once we receive a due diligence request list, we will have a call with the seller to go through the questions and prepare the responses ourselves. We'll prepare either a due diligence response list or due diligence response chart where we mark whether it's been provided. We will create the data room and folders within the data room to correlate with the due diligence requests being made. So if they're in a list with A, B, C, D through J, then we will create correlating folders to produce that information in. And then why is due diligence a non-negotiable step? I mean, I think it's the same thing if you were buying a business, putting yourself in other people's shoes and figuring whether you would feel comfortable spending hundreds of thousands or millions of dollars on buying a business without being able to review the contracts and understand really the components of a business and what it entails beyond just a mere description of it. So it's just a very typical part of every transaction, just like in real estate. Now, there may be some people who will buy cash without due diligence at their own risk, and that is a whole other area of the market. But for the most part, everybody requires due diligence. And it's really important to establish the buyer's confidence in the transaction. Buyers will be investing tens of thousands of dollars, if not more, in the purchase of a business. in legal fees, financial due diligence, and more. So they want to make sure that before they do that they feel comfortable that the business is what they think it is and that it is going to be a worthwhile investment for them. And so when we go through the process of preparing our sellers for due diligence, whether it's years before selling the business or as they're entering into the process, we start to talk with them about getting their documents organized, making sure they have easy access to all of their contracts, that all of their contracts are being saved. If they haven't been saved, saving them to an easy location so that we can access them, all of their organizational documents. Some of these businesses are made in the 70s or the 60s or even further before. And so we need to track down all of that organizational documentation because you have to legally be able to transfer the business. And to do that, you have to see the entire organizational history of the business and make sure that the transfer is consistent with and not inconsistent with those prior transactions. Typically, those due diligence requests come to your legal team and we assist you with that process of handling those due diligence requests. Sometimes the business team is copied, and if it's easy enough, then they'll upload it to the due diligence data room. But typically, most of those requests go through your legal team. It is so important to be very timely in responding to these because it will delay your deal and getting to closing, and it will also really take the forward progress out of a deal by have production of due diligence materials be delayed. So you want to be very timely. I would say always try to respond to things in same business day, couple business days, or at a maximum 4 business days to respond to things in a timely manner. That'll make sure that your deal is on track and continues to stay on track, and that you're able to sell the business in the same time frame that you had originally thought of. And we really work on managing this process so that it's a smooth process, so that you have confidence as a seller in this process, so that when you're going through it, as it may be intimidating and feel intrusive, that you feel confident that the information that you're providing is market, it's the right thing to do, that you're doing it in a conscientious way to protect your business and do it thoughtfully and intentionally. So mitigating risks through transparency. One of the best ways to mitigate your risks as a seller is to disclose. Now, you don't want to just disclose everything and anything that's not necessary. You have to be very mindful and strategic, and you work with your lawyer and your attorney on making sure that you are answering everything truthfully and disclosing everything that you need to. But if it's not relevant, it confuses the deal and overcomplicate things when it doesn't need to be. And so we work with our clients to make sure that they are being as transparent as possible, that they are disclosing as much as possible, because that will mitigate your risks in the transaction. Particularly, you want to make sure that the representations and warranties are all things in the transaction that you're able to stand by. And if there's any exceptions to those, that those are made clear, that you're answering all the due diligence requests. And if there's any covenants or anything like that that would benefit from disclosures, that we talk through what those disclosures would need to be. Let's get into phase 5, which is negotiating the terms of the transaction. And so, as I mentioned before, the first legal document and agreement that you'll be agreeing to, in addition to the non-disclosure agreement, is your letter of intent generally. Now, a buyer may submit an indication of interest. This is non-binding and will be just a little bit of information, maybe a range of purchase price or information about the key couple terms of the transaction. It's really not going to cover everything. It's not meant to be the foundation of the transaction. It's meant to be solely an indication of interest and showing that they are expressing interest. And usually this is done to gather additional confidential information that they need to be able to determine the valuation for the letter of intent. And then when you're going to go through the process of negotiating this, we do have an LOI checklist to make sure that you know all of the information that you need. So we are going to have with our masterclass the LOI checklist from a seller's perspective, and going through how to negotiate the transaction and making sure that the LOI is going to have in it everything that it needs as well. The masterclass will go into deeper information about what you need to do to prepare your business for sale, all of those things that we talked about, going through all of your contracts, all the things that we do in greater detail, but that you can at least get a head start on, and so that you can also understand what we do to prepare a business for sale. And so the masterclass will also include a checklist on the components of an LOI to make sure that you have a good understanding of what it is that you need to do to negotiate in the letter of intent. We also have a whole podcast episode about negotiating letter of intent and so much more information on this, but you essentially want to have all the key components of the deal because it is meant to be the foundation for your transaction. So you want to have the purchase price, the deal structure, payment terms, who's a party to the transaction, whether there's going to be your involvement post-closing, any transition services, any other material terms, if there's going to be a lease, if there's a property that you own that you won't be selling, or whether you will be selling the property, what the terms are of the real estate, whether it's going to be leased or purchased in the transaction, and any other material terms. And it's so important to do this right the first time because it really sets the tone for the entire transaction and whether it's a smooth transaction. And so we typically represent sellers in negotiating those letters of intent and making sure that they are right and good for the entire base of the transaction. And then in addition to that, you want to make sure that everyone's interests are aligned and that the letter of intent includes all of the key terms beyond just the actual purchase agreement, but also things like due diligence, like we spoke about, access to data, access to employees, access to customers, access to vendors, whether all of those things are accessible and permissible or not. And then also, how can the LOI be terminated? What is the exclusivity period? Exclusivity is standard in the sale of a business, but there needs to be parameters around it so that it's fair to both the buyer and seller. And the reason it's standard is because buyers are investing thousands and thousands, tens of thousands, sometimes hundreds of thousands of dollars in pursuing a transaction, and they need certainty that they're doing that and also able to close at the end of the day. And then you have, in addition to pre-LOI due diligence, then once you get the LOI, you're going to be doing post-LOI due diligence. So there's that integration of these two phases. And then in addition to that, you're going to have your purchase agreement and all of your ancillary transaction documents. Now, to legally transfer a business, you need a purchase agreement, and you will also likely need a lot of other transaction documents. If it's an asset purchase, that may be a bill of sale, assignment and assumption of contracts, and a number of other things. A non-compete and non-solicitation agreement is also standard in the sale of business, but it needs to be negotiated in a way that's fair for both parties, especially given the consideration being paid and the value of the business, and whether or not that's intended to replace the income and the career of the seller or not. And then also, if it's a stock purchase, there's a whole ton of different contracts that need to be done to legally transfer the business. And in either case, you're going to have consents, secretary certificates, officer certificates, and a number of other components to make sure that it's legally effective and binding. Now, the stock purchase agreement is going to have a lot of information in it. A lot of my sellers get nervous around this part because it might be a 25, 30, 60-page document with the purchase agreement. That can be standard. Length does not mean that they're trying to pull something over on you or anything like that. You want to make sure that these are fair. We obviously represent our clients in negotiating all of these transaction documents, and the purchase agreement will be the definitive agreement that's governing the sale of the business as a whole. There are going to be a lot of different parts of it: representations and warranties, covenants, indemnifications, and so much more that are going to be really important for a seller to go through with their attorney line by line. We do that usually when we're reviewing a purchase agreement with the seller. It's going to be a 2 to 3 hour conversation at a minimum to make sure that we're going through all the different parts to make sure that they fully understand everything. And then, of course, we're going to have to create disclosure schedules and everything as well for the purchase agreement. So there are pre-closing covenants, representations and warranties, and post-closing as well. We would go through how all of these things are impacted pre-closing and post-closing, and then making sure that we do everything that we can in our client's best interest to minimize the likelihood of dispute going forward. this is oftentimes just language and drafting and being good at your job to reduce the likelihood of disputes. And then also making sure that indemnification provisions, baskets, caps are all fair to both parties, and making sure that the buyer has protection post-sale for the actions of the seller pre-closing, and that the seller has protections from the business of any actions post-closing as a result of the buyers. So there should be mutual indemnifications there also. And then once we have all these transaction documents and we're going through that 60, 120 days for the transaction, generally from the LOI to closing, and there's a number of things that impact that as well. We're going to be negotiating, finalizing all the terms. We create a closing checklist. We collaborate with the buyer's counsel, who's creating the closing checklist, who's doing the first draft of documents, and then really finalize all of those nitty-gritty terms in all of the transaction documents and prepare for closing, tracking all of those deliverables, tracking all of the transaction documents, open items, and everything like that. So it's a really robust process that we go through, taking it from the very beginning all the way to closing. And it's something that having the right counsel will drastically increase your likelihood of success of closing, because it can be a very intimidating process, like I said, with emotional highs and lows. And we want to make sure that you are prepared for success. And then the last phase 7 is post-closing integration and transition. And so it's important to know at the very beginning of this level of involvement are you willing to have post-closing. There's almost always some level of involvement that a seller needs to have, because most of the time a seller has processes, standards of conduct, or standards of operation, all of that in their head, and not necessarily all written down what their procedures are. And so there is likely going to be some level of transition needed. Now, it has to be something that is good for both parties, relevant to the business, and also what's permissible. So SBA lenders won't allow a transition to extend more than a year. And then if it is not involving SBA, it may be longer than that, but it also may just depend on the preferences of the parties. Sometimes a seller is looking to get out and want to, wipe their hands of it, but you have to give the buyer enough time to get up to speed with the business and operate the business. So that may be a 3-month transition period, or maybe you'll have a 3-month full-time transition, and then the months 3 through 9 are 20 hours per week, and months 9 through 12 are 10 or less a week, or something like that. So you may take it down, and then you have to agree between the parties whether the seller will be compensated for that transition period, and whether they'll be an employee of the company, or it's included in the sale of the business, or whether there's separate payment for that. So tons of different aspects to selling a business. I do hope that this has been helpful and that there's been a lot of information that we've shared. Be sure to check out our masterclass, as well as the other resources that we have, like the guide on our website and the LOI checklist that we'll have in the masterclass as well. I hope this has been helpful. If you are interested in selling your business and would like our assistance at Dean Street Law, of course, feel free to reach out to us. Be sure to share this episode with anyone you might find would benefit, and we will see you in the next episode of Dealmaking with Laura DiFrancesco. Thank you for joining us on this episode of Dealmaking with Laura DiFrancesco. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please make sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please make sure to leave a 5-star review and share the podcast with anyone who may benefit from it. Sharing our podcast is the best way to show your support and help us to continue making more content just like this. So please be sure to take a screenshot and tag us on social media whenever you can. For more in-depth resources, be sure to visit our website at deanstreetlaw.com, where you can find articles, guides, and more information on our services. Or you can also visit lauradifrancesco.co/the-shop for more information on our legal courses. Don't forget to follow us and connect with us on social media for the latest updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LM DiFrancesco on X, and at Dean Street Law on Instagram. Be sure to join us on our next episode where we'll be discussing more deal-making tips and insights. I'll see you there.